3 or 4 years ago, I was contacted on the telephone by a freelance writer who was doing an article on current employment law issues for an employer's publication. He explained to me that he was speaking to employment law practitioners across the country to find out what the hot new issues were, and that's a bit of an oxymoron, I think, in employment law. He started our interview by saying, well, I guess the hottest issue is workplace sexual harassment, and was rather amazed when I responded in the negative, and said that at that time in my 10 years of practice, I could count the number of times on one hand that I had been consulted about workplace sexual harassment issues. I think at that point in time, the freelance writer talked about the high-profile American sexual harassment cases that were in the news, and wondered why Ontario lawyers, if I was at all representative of the group, wasn't being met with this invasion of workplace sexual harassment cases. I think I remember telling him at that time that, well, you know, sexual harassment is really discrimination on the basis of sex, contrary to the Human Rights Code, and because of a case called Bedoria, employees can't sue their employers in Ontario for discrimination. In my mind, at the time, that was all that really needed to be said on sexual harassment. Now, some 3 or 4 years later, I've been asked to speak at this first annual employment law forum on all topics sexual harassment. And if the complexion of my practice currently was reflective of what it was back then when I was interviewed, this would be a really short talk, and my paper would be even shorter. Fortunately, my practice has changed in the last few years, and I now can probably count on 2 hands the number of cases I've had in the last few months in which workplace sexual harassment was an issue. Times are a-changing, and I think the high-profile American cases that the freelance writer talked about with me have finally caught up with the public awareness, and that everybody's talking about workplace sexual harassment. In light of this increase in public awareness, we're called upon with more frequency than we used to be to help employees find a remedy for sexual harassment, or help employers determine how to handle it internally without litigation, and how to prevent future occurrences. As I noted earlier, Rolph in his discussion about workplace policies discussed the necessity of having a sexual harassment policy, and that, as you will see, is sort of the last part of my paper, and I'll try and steer away from that on my comments today. My paper really starts with what is sexual harassment. I won't go through that in any detail with you. It shows that pre-1982 we didn't have a specific provision against it in the Ontario Human Rights Code. Effective 1992, we do have specific wording, Section 7.2, which provides that an employee has a right to freedom from harassment in the workplace because of sex, and 7.3, which says that every person has a right to be free from a sexual solicitation or advance in the workplace, or be a reprisal or threat of reprisal for the rejection of a sexual solicitation or advance in the workplace. If you look at the early cases on sexual harassment, there's a big distinction between what was called sexual quid pro quo sexual harassment and poisoned work environment sexual harassment. There's a discussion of those terms at page 6 of my paper. In very layman's terms, the poisoned work environment is really what's dealt with in 7.2. where it says, of the code, where it says an employee has a right to be free from harassment, which is then defined, although sexual harassment per se isn't, as meaning engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. So it's also been referred to as sexual annoyance, sexual harassment. It doesn't directly translate into conferring or taking away of benefits or status. Quid pro quo sexual harassment is what's dealt with in Section 7.3, and this category of sexual harassment results in either some direct consequence to the employee's employment status or employment opportunities, or in some gain or loss of the employee's job benefits. In those sections of the paper, I have set out sort of classic examples of those too. What legal remedies are available for victims of sexual harassment? I mean, the first place to start to look is at the workplace and whether the employer has put together an internal anti-harassment or anti-sexual harassment policy. If you look at the Ontario Human Rights Commission's policy on sexual harassment and inappropriate gender comment and conduct, you'll see that the Commission strongly encourages employers to have these policies. If you're a federal jurisdiction employer, you're statutorily required to have an internal sexual harassment policy. So if there's a policy available in the workplace and a procedure set out, it's worth the employee exploring whether that's a possible way of dealing with the complaint. It can obviously be less time consuming than other forums and has the potential to be much more cost efficient. The big perception problem that I have speaking to employees who are in workplaces that have those types of policies, they're concerned that, well, it's all well and good and the employer may do an investigation, but I think at the end of the day it's in the employer's best interest if they find that there wasn't any sexual harassment, so I don't want to go that way. Obviously, there's the option of filing the discrimination on the basis of sex or sexual harassment complaint under the Human Rights Code. Subsection 34.1, the Commission has the discretion to decide not to deal with the complaint. If you look at page 9 of the paper, it talks about different grounds on which it can choose not to deal with the complaint. The one that my employer clients tend to get all fired up and excited about is the one that says if the facts in the complaint occurred more than 6 months prior, then the Commission has the ability to decline to deal with the complaint. I've had a number of officers tell me that, well, we don't really do that in sexual harassment cases because the nature of the intimidation kind of tactics that are all part and parcel of sexual harassment lead to the employee inevitably not coming forward in a timely fashion, so we're not going to preclude them if they're a little tardy in filing the complaint. The Commission's then required to conduct an investigation of the complaint and attempt to settle it. I know in London there is a lot of voluntary mediation that's done at the urging of the Ontario Human Rights Commission, and is probably a concerted effort to get rid of some of the backlog. That's been the sort of chief complaint, I guess, among practitioners who are advising clients who have complaints under the Human Rights Code. You're often measuring in years the length of time it takes to get a remedy, and in a number of years more than it would take in a courtroom setting. The commission discussion on page 10 of the paper about the different remedies, however, that are available to the commission, a key one, which a court traditionally doesn't have, is that of reinstatement. Now, in light of the perception problem with the internal mechanisms that an employer might have to deal with sexual harassment, and in view of the often time-consuming nature of proceeding under the Human Rights Code, you have employees coming to their lawyers saying, really, there must be some alternative. Because of the 1981 decision of the Supreme Court of Canada and Seneca College and Bedoya, which I mentioned earlier, an employer, the court has said that an employee can't sue the employer for discrimination or for a breach of the Human Rights Code. So in Ontario, there isn't a tort or a civil cause of action for a human rights violation. Got a discussion of the background facts at page 11 and 12 of the Bedoya case. But suffice it to say that Bedoya is still the law in Ontario, although I continue to receive statements of claim where Employers' Council is purporting to sue for damages for sexual harassment, which of course immediately ends up in a letter going back from me saying, oh, where are you getting that tort from? There have been some attempts to say that the courts have concurrent jurisdiction. It seem to be in Manitoba or cases under the federal legislation, and they're cited at page 12 of my paper, 12 and 13, and they're really focusing on wording that's quite different than that contained in the Ontario Human Rights Code. Now, although the courts in Ontario have prohibited sexually harassed employees from suing their employers for violations of human rights legislation, the courts have permitted such employees to sue their employers on a variety of other grounds. There have been a number of cases dealing with constructive dismissal. Three that I touch upon on my paper, the first being Alpertz and Obrant, and in that case, the plaintiff sued her employer for damages for constructive dismissal. She alleged that the sexual harassment to which she'd been subjected constituted a fundamental breach of her employment contract and therefore was tantamount to a dismissal. The employer argued that her only recourse was to file a Human Rights Code complaint and brought a motion on the basis of Bedoya to strike out the statement of claim on the grounds that it disclosed no reasonable cause of action. The motion was dismissed, and the court distinguished Bedoya by noting that while in that case, the Bedoya case, the employee had claimed damages for discrimination. In this case, Ms. Alpertz was claiming damages for wrongful dismissal. The court noted that while Ms. Bedoya's claim flowed exclusively from a violation of the Human Rights Code, Ms. Alpert's claim flowed from her employer's wrongful, albeit constructive, termination of her employment, and accordingly the court allowed her claim and concluded that there was nothing in the provisions of the Ontario Human Rights Code which prohibited her from suing her employer for wrongful dismissal. A similar decision in Lehman versus Davis, and also a similar decision involving a federally regulated employer referred to on page 14 of my paper, La Boudière versus Royal Bank. There's also been other causes of action asserted that essentially stem from a scenario of sexual harassment. In Kulik versus Toronto City Board of Education, the plaintiff commenced a civil action against her former employer claiming damages for constructive dismissal, willful or negligent infliction of harm, and loss of reputation. She alleged that these damages flowed from the employer's sexual harassment and differential treatment. Not surprisingly, the Board of Education, argued that she should be barred based on the ruling in Bedoria. And the motions court ended up dismissing the Board of Education's motion and, in effect, said that there were a number of grounds that she had asserted. With respect to the intentional infliction of mental anguish, they noted that that may be a cause of sexual harassment, and I would be surprised if it were not. However, intentional infliction of mental anguish or suffering is an independent tort, which is recognized by law, and permitted her case to go forward. Similar result in Sargent versus Patterson Dental Canada, constructive dismissal, defamation, intentional or negligent infliction of harm, breach of privacy, breach of fiduciary duty, and negligence or gross negligence. And I think the salient point of the court's decision, as outlined on page 15 of my paper, although the decision in Bedoria would bar an action for damages for sexual harassment per se, it does not oust the jurisdiction of the court to try an action for damages based on an independent tort or torts, or based on a breach of contract, whether or not there is a pending complaint before the Ontario Human Rights Commission. And I believe in that case, she had also filed a human rights complaint. I also look at possibility of claims under the Occupational Health and Safety and Workplace Safety and Insurance Act, and in short term basically conclude that there's not much of a hope going there. Deal with the policy, and then finally the paper deals with disciplining employees who violate an internal policy. Cases really seem to deal with serious incidents of sexual harassment, which would warrant the immediate dismissal of an employee, versus less serious, which the courts believe require the employer to warn the employee before terminating his employment. Thank you.
Thank you. On the Sargent and Patterson Dental, having lost that case, what was before the Human Rights Commission was absolutely identical, word for word, as to what was in the statement of claim. So it was apparent after that case and our loss on that case, that the courts will definitely hear these cases, because we showed the judge it wasn't rocket science. Everything in that human rights complaint was exactly what was in the statement of claim. They didn't even bother taking any magic or playing with it, and it went forward. Fortunately, we settled it at mediation, because it wasn't the prettiest of 40 pages statement of claim with its allegations, which I wouldn't have crossed the border with. The Sargent and Patterson.
Jack Braithwaite is a partner with the firm Gatian Braithwaite in Sudbury, which is the leading management labor firm in Northern Ontario. He worked for us getting his groundings in employment law, and has been doing much of the labor law in Northern Ontario since then. He's also co-wrote Stacey Ball's book with them, Canadian Employment Law, and doesn't get as much of the press as Stacey, but in fact, only in Northern Ontario, that's right. I was associate editor of the Dismissal of Employment Law Digest, one of my publications.
told I have very limited time left, and I had a little PowerPoint show to give you. I'm not sure if I can get it going within the 10 minutes.
All right, 12.
I've been asked to talk to you on occupational health and safety issues. And whenever I'm asked to talk about that, I think what we have to appreciate is that what's happening in occupational health and safety right now is fairly vast. And given the limited time that I had, I couldn't possibly deal with the issue in the manner that I would like to deal with it. So what I've done for your reference is I put together a case comment. And the case comment that you have before you is Sarnia Cranes. Now that's an interesting case because ostensibly it's about putting together a drug testing policy, but that's not what interests me as much as anything else, is that particular case, it's a case that followed Entrop Imperial Oil, which is probably the leading case dealing. You like this? This is my Jordan days. Jordan in action. But the case that, the Sarnia case that you have before you, the significance of that case is that unlike the Entrop case, I mean, it's the same finding as the Entrop Imperial Oil case, but the Sarnia case is, just give me a second here. The Sarnia case, as I said, it fell in between the Court of First Instance, or the Board of Inquiry, and the Court of Appeal case. But it does an interesting analysis on drug testing. But for our particular purposes, the point that I want to get out of that case is that it dealt with the priority of jurisdictions in dealing with either, or the priority of legislation, dealing with the Human Rights Code and or the Occupational Health and Safety. What comes out of that case is that the legislation which prevails will be the Human Rights Code. Now, I thought that was interesting in itself, because what that does is it provides some interesting implications for the employer. Because the interesting thing about that, I'm still going. Technology, indeed. The interesting situation about dealing with the priority of the Act is that when we talk about the Occupational Health and Safety Act, the issue that we have to deal with, or the direction that we end up having to relay to our employer, is that at one point, if we looked at the history of dealing with these kinds of issues, particularly when we were dealing with human rights, privacy concerns versus health and safety concerns, the question is, what is the priority? In this particular case, the Sarnia case, what it was in this case, the Sarnia rented cranes and other equipment, and his biggest client was, interestingly enough, was Imperial Oil. And they insisted that Sarnia, in order to do business with them, have a drug testing policy. So they implemented one. It was struck down. But nevertheless, in dealing with that, the board does an analysis of drug testing and eventually looks into the whole aspect of the Human Rights Code versus occupational health and safety, determines that occupational health and safety should play, I would suggest to you, second fiddle to the Human Rights Code. And that case was heard before the Ontario Labour Relations Board. With the Ontario Labour Relations Board, anytime we were dealing with occupational health and safety issues, is now the jurisdiction is the Ministry of Labour, and it's heard before the Ontario Labour Relations Board, as opposed to the Human Rights Code, which in this particular case was a Board of Inquiry, and eventually made it up to the Court of Appeal. So the analysis is interesting because the analysis comes from a labor, occupational health and safety perspective, dealing with the Ontario Labour Relations Board. The eventual outcome of that is that when you're advising employers about one or the other, the history has been you always try to find that balance. Primarily for the employer, it's safety. Safety comes first, and then after safety, we start dealing with trying to get that balance with, yes, privacy right concerns. This particular case almost sort of tips the balance. It tips the balance to the point where the employer is being told outright, privacy concerns should override the safety concerns. In practice, we would submit that doesn't really work because of the cost of such adventure. And the cost of that is looking at the legislation, and if we looked at the legislation, we would have to be concerned with respect to the extent of the liability. And it's the extent of the liability that will, I would suggest to you, determine what employees do and where they go. And now I'm in. We're on our way. If we look at the legislation on the Ontario, the Human Rights Code, and we were to review and I've placed it in the back of the text, a table of the significant cases over the last year. And if you view the table, one of the things that's which is striking, are the level of, or the extent of liability. The extent of liability is fairly significant. Here under Section 44, you'll see, and this is of the Human Rights Code, you'll see that every person who contravenes Section 9 or 11, the key thing here is to look at the liability is about $25,000. What I've also done is I put a list of about the 5 significant cases of the past year and the extent of liability that you'll see under them. Here we have curling versus, these were grounds of gender and sex. And if we look at if we look at the extent of the liability, you see humiliation of loss and dignity, 14, mental anguish, 20, and so forth. And so out of the 5 cases that I referred to, I put together a little chart, and you can see that the 5 significant cases of 1999, that the leading range of liability was around $50,000. Now, under the Canadian Human Rights Act, the legislation there indicates that the penalty would be $50,000, a little higher than the Ontario human rights. We looked at some cases, the 5 significant cases over the past year dealing with Canadian human rights. Total up, there was 2 different awards handed in this particular one. We totaled it up, put it on a chart, and this is what it looks like. It was a Chander case, and the one right down the middle, about $70,000, and we looked at about 5 cases. You can see to the side, the same Koval, Goya, Chander, and Radiovanovich. That's what you're looking at in terms of liability. Now, comparing that to Occupational Health and Safety Act, now you can see that for an individual, the penalty is about $25,000, and with respect to a corporation, it's $500,000. Looking at the number of significant cases over the past year, you can see that in the middle one, the WCL Chem, there was a fine over $700,000. $700,000 compared to what we saw under the Canadian Charter of Rights. The best they were able to do under that one was $70,000. And the specific penalty provisions are never really applied. It's usually the damage award itself. Now, under the under the Canadian, under the Human Rights Canada, you can see here that this has been recently amended. And you can see what we're looking at here. They've kicked it up to $1 million. $1 million fine to corporations, $100,000 summary conviction. However, if there's a death or injury, either one of them will get you $1 million in prison and $1 million and/or imprisonment. And on summary conviction alone, $1 million. So when we start looking at which takes prevalence, either the Human Rights Code or Occupational Health and Safety, and you're talking to your client will generally end up choosing their liability. I would suggest to you that what the liability that they'll be looking at is they'll be more safety conscious than they would about the privacy of rights. So that's the only point that, in terms of this particular talk, that I think that you're going to have to look at your clients at in terms of, or address your clients with in terms of the liability. Now, a couple of other things that are also emanating out of issues that are arising out of occupational health and safety, and I just want to briefly mention two other issues which are pending. One of the interesting one is telecommunications or telecommuting. Where that raises its head is on home offices. Home offices are something that are starting to raise its head in light of information like this, in light of information technology. And what's happening is there's a growing expanse of people working at home. And that's sort of a wave of the future, whether or not we'll end up having more people working at home than in the office itself. Now, with that happening, there's some interesting developments going on, particularly in the U.S. And the interesting developments happening in the U.S. is how does the occupational health and safety deal with those kinds of issues at the home? Presently, in the U.S., there are developing legislation around that. Canada has not done that yet, but it is suggested that Canada will eventually have to deal with that particular issue. If that is the case, and or something of that nature comes up, or any of your clients are speaking to you about what are my liabilities if I open up if I have a few of my employees stay at home and work, well, the things that, in order to protect themselves, what I would suggest that they do is put together a telecommunication or a telecommuting program. And that program would probably address itself dealing with a few issues such as workplace area and workplace safety. They may want to look at a few things and incorporate into their policy so that they may avoid some of those rather stringent kinds of penalties that are out there, which may very well be, I'm told I have 10 minutes, did you say?
Yeah, you've now. This is in deference to the Northern Ontario contingency.
I'll just sort of wrap it up within 30 seconds. Just a few things I want to say. In terms of if you're putting together a policy of and looking at the home and looking at workstation, the kinds of things that you may want to put in your policy is or advise your client is to address certain particular issues, such as putting together a separate and private room, a place which is private and quiet, a place which is secure so that the documents or anything else aren't destroyed from children or pets or anything else of that nature. They should also look at work area safety, make sure that things are cleared out of the paths, that possibly a smoking detector, that there's good air ventilation. These are the kinds of things that employers may want to look at in putting together a telecommuting program if, in fact, they're going to be moving in a direction and having some of their employees work at home. There was one other aspect which is coming out, but I'll bow at this time to time, and I thank you very much.
Thank you. Thank you, Jeff. Thanks very much, Jack. I know it's really tough to deal with that topic in the confines of 10 minutes or 20 minutes or even 2 hours. Neil Ornstein is with the management labor firm of Matthews, Dinsdale, and Clark, but he's just not simply a lawyer who has an extensive practice in that area. He's also an artist. with his computer, and has a showing, and this is why he's here, because this is a plug for his show at Prisma and Dessiné. So not only will you enjoy listening to him talk about the issues of a funny thing happened on the way to the forum, but you can also take in his art. If anybody's visiting from out of town, please, what time's the show?
Oh, no, it's ongoing. So I can either demonstrate how to paint on your computer, or I can talk to you about places you can go to sue. I assume you'd rather me do the first, but in fact, I'm going to do the second. Thanks. Because of the way that this conference is set up, I'm going to talk briefly about Canada Labour Code, Ontario Employment Standards Act, Workplace Safety and Insurance Act, and finally, if there's time, and there may well not be, Human Rights Code. In terms of Canada Labour Code, something that many plaintiffs' lawyers aren't aware of, and from the defense lawyer's perspective, all I can say is thank God, is unjust dismissal proceedings under the Canada Labour Code. Tomorrow, John Sproat is going to be doing an extensive seminar on that, so I'm not going to do anything more than touch the surface of it. But basically, these proceedings are available to you where you represent a client who's had 12 or more months continuous service, who is not a manager within the meaning of the Canada Labour Code. And I would say to you, if you look at the case law, many people that an employer may think are managers, that have the title manager, may not truly be managers within the meaning of the code. The case law has given it a fairly restrictive interpretation. Persons who are not subject to a collective agreement, and persons who are not laid off due to absence of work or discontinuance of the function. These people may have a remedy under the Canada Labour Code. A crucial point from a negligence of lawyer's negligence point of view is that there is a 90-day period for making such a complaint. The 90 days runs from the date of dismissal. If you miss that time, or if, God forbid, you go to the wrong place, you send them off to employment standards provincially instead, the good news is that there is discretion to extend the complaint if it is made to the wrong agency, provided you had your client or you believed that you were going to the right place. What I found out to my chagrin recently is that there doesn't appear to be a time limit for applying to the minister to exercise his discretion to extend the time. So I'm dealing now with a case where years after the fact, the person's coming back and saying, oh, well, I went to the wrong place, now let me in the door to make an unjust dismissal complaint. And amazingly, the minister said, okay, even though some 4 or 5 years had passed. So that 90-day rule, as long as you go somewhere, you may be able to get around it, even if you went to the wrong place. If, however, you don't go to any government agency, you're stuck with that 90-day rule. So when the person comes in the door, that's the first thing you should be thinking about. Are they employed by a federally regulated employer? And secondly, are we coming up against that 90-day rule? What's crucial about the Canada Labour Code, and John Sproat will be going into it in very considerable detail, is that you have a range of remedies that are considerably broader than are available in a civil action for wrongful dismissal. In particular, you have a remedy of possible reinstatement, and you have the possibility of damages not limited to a common law period of pay in lieu of a reasonable notice. Two areas, and I as a defense lawyer, I really don't want to tell you about these things because I really don't want you guys coming after my clients with them. But two very underused provisions are under the Canada Labour Code. One is the sick leave provisions of the Canada Labour Code. And there the requirements are 3 months continuous service prior to the absence and an absence not exceeding 12 weeks. The scope of the remedy, and here I say damages not limited to common law pay in lieu of notice. damages for failure to continue certain benefits, pension, health, and disability benefits during the period of leave. I say that with great assurance. In fact, when you look at the Act, it's not quite clear how far the remedial authority goes. There's certainly, I guess, from the defense point of view, a risk, and from the plaintiff's point of view, a potential opportunity that you can get damages not limited to a common law period of notice, and that you can impugn the fact of dismissal altogether. And how this ties in with, for instance, a defense of innocent absenteeism, it may override that defense. May. Don't say will, but may. Even more, I guess, giving to enthusiasm if you're on the plaintiff's side, or giving to despair if you're on the defense side, are the work-related injury provisions of the Canada Labour Code. Now, if you're at all familiar with the Workers' Compensation Act of Ontario, there is a reinstatement obligation on the part of employers that runs basically 2 years from the date of injury. And people know that they have to comply with that, and then there's a 6-month period thereafter that if you don't reinstate the person, or if you do reinstate and then fire within 6 months, you're presumed to have breached the Act. Under the Canada Labour Code, there are some similar provisions. The key point, though, is that there's no minimum continuous service prior to absence, so the person can be hired on Monday, can slip and fall on Monday at 4 p.m. just before going home, and then there is no limitation on the length of absence. Once again, there's a real question that damages may not be limited to common law pay in lieu of notice. There is an obligation to continue specified benefits, again, pension, health, and disability benefits, for the period of absence. And if you look at that Act, and it's very curiously worded in some areas, that may go on ad infinitum. And so when you have somebody who has been off for 7 years and your client comes to you, now maybe we're wearing a defense hat, and says, you know, we really want to get rid of this guy's benefits because he's costing us a lot and he's been off 7 years, and don't we have a defense of frustration? The answer is all of that may be swept away by these provisions of the Canada Labour Code. I had occasion to look at some of the case law as to whether a defense of frustration survives this particular provision of the Act, and the best answer I can give you right now is I don't know, and I'm concerned, at least wearing my defense hat, that it might not. However, when you're wearing your plaintiff's hat, boy, this can be a good one. Turning now to Ontario Employment Standards Proceedings. It used to be that you could have Ontario Employment Standards Proceedings to get your basic statutory remedy, and then you could rush off to court for the icing on the cake. And indeed, if you won at the Employment Standards branch, you might then be able to say that that was then issue estoppel, and the employer was bound by that determination and could not then assert a defense of just cause in a subsequent civil action. Now, the flip side of that, of course, was that if you lost as a plaintiff, you were bound by that issue estoppel as well. Well, all of that is now ancient history. The Tories basically came in and they said, now you've got to choose. And so what I'm now going to talk to you about are some criteria for deciding when you should nonetheless consider employment standards proceedings. The key and basic issue really is the amount that your client is seeking to recover. For most types of claims, the Act imposes a $10,000 cap. However, that cap does not apply to claims arising from a contravention of the pregnancy and parental leave provisions, from the part that deals with termination or discipline as a result of lie detector tests, and from some of the rights arising under the sections dealing with retail business establishment. There is no cap for those, and there is very broad remedial authority with respect to these latter claims. I should also note that in the proposed amendments to the Employment Standards Act, they are thinking of bringing in family leave provisions, so leave for family crisis or illness or injury of your child or parent or things like that, with some parallel protections to those found under the pregnancy leave provisions. That will be a wonderful make-work program for lawyers, because now just about anybody who took a day off to look after their child will now say that when you look at them sideways, it's a reprisal for having done so. So it's going to be wonderful. We're all going to get rich off that one. A key point that you should consider under the employment standards provisions is that there is, one, no availability of a costs award should your client be successful, and, however, conversely, no exposure to a cost award should your client not be successful. The other thing that you should be thinking about is representation. Since nobody's going to pay your freight on a cost award except your client, is it safe to send your client down there without your representation? Well, in a straightforward case, certainly my experience has been that your average employment standards officer tends to be favorably disposed towards the employee and will look after them. Certainly if the employment standards officer fines for the employee initially, and then you're into a situation where the employer is appealing to the labor board, there the Ministry of Labor will usually take an active role, appoint lawyers to uphold the ministry's, the officer's opinion, and therefore look after your client. Couple of key points. Where your client is terminated and manages to land on their feet almost immediately, and so thereby precluding a successful civil action because they've mitigated their damages, under the Employment Standards Act, principles of mitigation do not apply. Where the person has been given notice, actual working notice of termination, they may not have a proper claim at common law. However, if the notice wasn't given in the way that the Act prescribes, they may still have a statutory claim for notice. For instance, oral notice, many referees have held, is no notice at all. Notice delivered by ordinary mail is no notice at all. So you may still have a claim under the Act for notice, even if notice was given. You may also still have a claim for severance pay, even if severance pay was paid as part of a sort of salary continuation or bridging arrangement. There is some case law that says that if you don't pay it as a lump sum, the person may be entitled to get it all over again. Bad news for employers, but if you're looking after an employee, that might be something to look into. Standard of cause. Under the common law, there is a lower standard of just cause than is found under the Employment Standards Act. Under the Employment Standards Act, you're looking at the test of willful misconduct or willful neglect of duty that has not been condoned by the employer, traditionally a higher standard. So if the amount that's an issue is not a problem for you, you may well be justified in going for that higher standard under the Act in a close case. Speed of proceedings, it varies from place to place and time to time, but typically the Employment Standards Branch is pretty quick. It's much, much, much quicker than the Human Rights Commission. And this can be very important where you're dealing with a potentially insolvent employer to get in there and get your money quickly. The other thing is that where the employer wishes to contest that adverse finding by the Employment Standards Officer, they have to pay the money into court, as it were, before they have the right to appeal. So this is a very useful provision. One last point. Under the Employment Standards Act, typically employers are not allowed to assert counterclaims or set-offs, which they would be allowed to assert in a civil action, and that may be another reason to consider the Employment Standards Act under circumstances where you might otherwise give it a pass. Finally, one last point though, if you go to one, you can't go to the other, so you really have to turn your mind to choosing. There's more to say, but there's no time to say it. Thank you very much.
Anand, why don't you come up? And we'll take whatever questions there are.
Hal?
To any or all.
Neil?
Yeah. Yes, go ahead. I'll just stand here, just give an extra seat. I think what you said, I'm not sure I heard what you said. It was, just repeat. Oh, okay. It was found that there were two employers. One of the speakers suggested might be the case, I think it was Mark Geiger, when an agency hired a computer person to an employer. Well, I don't know that, it's not the hiring act itself. It's when you have one of these placement agencies that actually places the contractor or employee who then continues to work under the aegis of the agency. So the agency pays their wages, the agency ostensibly supervises them, yet they effectively work integrated in the workplace itself. There have been cases suggesting that both the agency and the employer continue as employers. So you could sue either or both of them, jointly or severally. Well, I guess people want to leave on time. I'll see you tomorrow at 9 o'clock.
Thanks, guys.